Ethics 101. Pay attention. In the previous video, we talked about Rule 5. Now we're going to talk about Rule 6, which focuses on retirement from judicial positions or public employment. I'll dissect it into parts for critical understanding. If you're a judicial officer in a superior court of record, then you can't be an advocate after you retire. The Nigerian Law School churns out at least 2,000 barristers every year. How are they going to compete with a retired honorable justice who has years of experience under his belt? They already have a difficult time competing with the legions of senior advocates of Nigeria. It's just going to be overkill at that point. There is an exception to this part of the rule, however. The retired judicial officer can defend himself in court, and in that instance, the court will grant him audience. Another highlight is that retired judicial officers can't sign pleadings for the purposes of any proceedings. This makes a lot of sense because the signature of a retired honorable justice holds a lot of power and influence, which would make us question if the presiding judicial officer has been compromised or not. While judicial officers can't appear in court for another person, they can practice as solicitors or legal consultants. This is because they have vast experience in law, and it would be a waste to just let all of that vanish after retirement. The legal consultancy could be on matters that he may have adjudicated on, or on fresh matters. It goes without saying that it's impossible for a judicial officer to be an advocate at the same time during his tenure. He can't even be a solicitor in that instance. This is because a judge is to be seen as an impartial umpire, and a judge advocating and soliciting could fetter his discretion. Also, a retired judicial officer may continue to use the word justice as part of his name. It's an honor. It's important to state that magistrates aren't judicial officers, so this rule doesn't affect them. Now that we are done with the first category, let's head into the next one: retirement from public employment. Now, what about lawyers in public employment? Can they practice after retirement? Can they act as solicitors? The RPC states that they can neither practice nor become solicitors over matters they've dealt with as legal practitioners while in office. The rule also contemplates a situation where a public officer may have been appointed in judicial capacity to oversee tribunal proceedings. He also won't be able to practice or be a solicitor for such matters that he adjudicated upon. Now, there's a question that hasn't been answered yet. What if the judicial officer didn't retire but was dismissed from office? Would he still be able to practice? Well, Section 292 of the 1999 Constitution helps with that. Looking at the provisions, it says that after such a dismissal, he cannot appear as a legal practitioner before any court or tribunal. This means that he cannot also sign pleadings of any proceedings as well. Now, there can be an instance where the judicial officer wasn't dismissed but voluntarily resigned from office. Can he still practice? We can reference Section 292 sub 2 of the Constitution again, paying close attention to the phrase ceasing to be a judicial officer for any reason whatsoever. This means that if you resign voluntarily, you'll be on the same boat as the judicial officer that resigned at the age of retirement, and you'll be barred from advocating for the same reasons. And that's all you need to know about Rule 6. Thank you very much for watching, guys, and remember, stay lawful, stay informed.